All right, so I want to leave some time after our last topic for questions, so let's get right to that, and that's wage and hour litigation. Maybe 10, 15 years ago, the rise of larger scale wage and hour actions caught a lot of employers with their pants down, so to speak. A lot of practices that were very common and turned out to be illegal. And so I guess my question first for Wayne, and then, I don't know, Betsy, do you want to jump into this one also? Is whether that wave is going to continue or whether employers have gotten their act together and basically figured out how to comply with the wage and hour laws?
Yes and no. That's a lawyerly answer. Some employers have gotten the message over the last decade especially that they can't keep getting away with violating the wage and hour laws. There is a small category of these cases where there's a legitimate disagreement as to how the law applies, as to whether a particular category of employee is exempt or non-exempt, and therefore, if non-exempt, entitled to overtime. There are legitimate issues, and in fact, there's one in the United States Supreme Court right now that is one of those cases in the gray area. But much of the time, there is no grayness, and employers are just trying to get away with what they can get away with. And many of them have, at least until 10 years ago, figured, well, this is just a cost of doing business. If I get caught, I'll put up a fight, I'll litigate, I'll slow it down, and eventually I'll settle, and then maybe I'll go back to doing what I'm doing. We have recidivist defendants. We have one company that we've sued, I think, 4 times now. We sue them, they did the wrong thing, they eventually pay up, and then they go back to doing what they were doing. And so we hit them again. So some employers really just don't get it, and they just consider these situations to be a cost of doing business. I hope that none of you in here have that view. I think you want to try to comply with the law. If you want to try to comply with the law, you can do so. Although the wage and hour laws and regulations are really intricate and complex and sometimes vague and hard to comprehend, and that gets you into that gray area in the middle. But most of the time it's pretty clear one way or the other, and an employer that wants to comply with the law 98% of the time can succeed in doing so without any risk.
Well, I would, I guess, say that I think the litigation in this area is going to continue. It's clearly burgeoned over the last 10 years, thanks to Wayne and his colleagues in particular. And I think that the message has been addressed. I mean, of course, there are, going to be firms, and when in particular in tougher economic times, are not perhaps going to have the same degree of motivation. But I think there are probably more situations that are close cases and difficult calls than Wayne would acknowledge. But we see a lot of employers doing audits, taking steps to try to make sure that they are complying, because they now realize perhaps much more than they did, a number of years ago, that the consequences can be very costly, and if they are compliant, at least on a going forward basis, there's less likely they'll get involved in litigation, and there are steps they can take to try to avoid it.
So Ron, do you think employers are you advising employers to start extending those arbitration agreements with the class action aggregate litigation waivers to other classes of employees who might be involved in this kind of litigation? And will that shut down some of these cases that are not litigable or arbitrable on an individual basis?
The answer, of course, is, notwithstanding Judge Wood's decision that in wage and hour cases, it is so difficult for an individual employee to get legal representation when he or she only has a singular claim. Ergo, it's a contract of adhesion to require them to sign agreements that forfeit their rights to be part of a larger group. I do think that we're going to shut down this cottage industry that emerged about 3 years ago. We're crowding the dockets of almost every federal court, while the wage and hour cases that typically a small to medium-sized law firm has decided to gin up. Let's focus on a few other things. If an individual employee says, I would prefer a different job title, I'd prefer a salary to an hourly rate of compensation, I'd like the status and stature of having a different role in this organization. I don't want to bother with timesheets. And the employer says, okay. Things don't work out, and now that employee says, I've been misclassified. The employer made me do it. It's the employer's responsibility to maintain records, and if not, there's a presumption, as a matter of law, that the failure to retain records should allow the court to conclude, by way of an adverse inference, that the records would have shown the truthfulness of what the employee says were his or hours of work, even though the employee had said, I don't want any part of timesheets. How about the former employee or the prospective employee who says, I don't want to get withholding in my check. I'd like to work as well for other organizations, even part-time. I want to be an independent contractor. And the employer says, that's a pretty good alternative to putting you on the payroll as a regular employee. Let's have an agreement to that effect. Well, suddenly, the grass wasn't as green as the individual thought, the other jobs aren't around, and he or she says, I've been misclassified. I should get some back pay and put back into some benefit programs retrospectively because I was never really an independent contractor. So is it really that we have only recidivist employers? Or do we have individuals who try to fashion new lifestyle arrangements with companies that don't always work? And what's driving this now? The economy. That's why the governor of the state of New York has asked for more audits and investigations of the alleged misclassification of individuals to independent contractor status. They want more tax revenue. And that's what this is all about. And that's the mystery behind why 3 to 4 years ago, Pandora's box just opened with this flood of wage and hour litigation.
Wayne, I'm going to give you just a couple of minutes.
Oh, wow. I could go all morning. This program is called Hot Topics. Well, this is one. And I think Ron and I could go mano a mano till noon on this one. There are so many things to say. First place, this is an example. Ron's a wonderful, vigorous advocate, and he's using the classic straw man. You set up, a narrow situation, and you knock it down. He did a fine job with that. But that is not the typical situation. That's a compliment, Ron. But that's not your typical situation. If it were, we wouldn't have 125 wage and hour class actions in our firm. We don't get paid by somebody to bring these cases. They're contingency cases. If we didn't have a good case, we wouldn't bring it. We only bring cases where we believe the law has in fact been violated. And as a practical matter, it has been. Otherwise, we wouldn't be bringing it, and we have never lost a case on a wage and hour claim, because the law is being violated. Now, Ron has a legitimate point. The law is complicated, arcane, Byzantine, irrational even at times. He's got a legitimate complaint about the complexity of the law. We all have to live with that. You have to live with it. Employers and employees have to live with that. I can't do anything about that. The gripe there is with the Congress. Fine, go fix it. But until that happens, the law is what it is, and we need to make sure it's complied with. Now, on this issue of arbitration, this is one of the most Byzantine developments that is unimaginable. If 20 years ago, before the Gilmer decision, I had asked anybody in this room whether an employer could have every employee who works for the company, when they start work, sign an agreement that says they promise that they will never, ever in the history of their employment or afterward bring any class action or collective action against the company, you would say, what a bizarre idea. How in the world could a company possibly get away with that? Well, through a series of bizarre developments, which I won't waste time on now, we've ended up in a situation where, through the magic of a two-step process, an employer can attempt to do that. One, require employees to sign an arbitration agreement, and number two, prohibit the arbitrator from employing a class or collective action. Ipso facto, the employer is immune. And that means that every employee who's got a small wage and hour claim, they're not being paid overtime, they're not being paid minimum wage, the tips are being withheld, would have to bring an individual claim, even though if their claim individually is only worth $1,000 or $2,000 or $3,000. That's absurd. That is essentially barring the courthouse door to employees who have legitimate claims for wage and hour violations. And so this is an area where the plaintiff's bar is going to fight to the death to preserve the right of employees to bring class and collective actions.
Well, on that potentially violent note, I think we should let the audience get into the mix here a bit. We have just a few minutes for questions. If you have a question, please keep it very, very brief and loud.
My question is about autism spectrum disorders and disabilities that are coming out now, especially with the Generation Y. How is that going to affect the discrimination lawsuits?
I missed the first.
Anybody have experience with discrimination lawsuits involving autism spectrum individuals? There was something in the news right today about changing the definition, right? Anybody have any experience with those cases?
Yeah.
Sorry, we're going to have to go to the next question.
This is an arbitration question, and I'm going to use a proxy for an employment law case. Citibank was in arbitration relating to muni option bonds. They lost the arbitration. The plaintiffs were awarded $25 million, $50 million. Citibank is now taking them to court. They don't like the ruling, so now they're going to go after the arbitrators. Will cases like this affect the viability of arbitration? I mean, what it comes down to in the end is you force your employees to arbitrate, you lose the arbitration, then you take the arbitration panel to court for failure to apply the law.
All right, so will there be the rise of litigation challenging arbitration rulings and trying to go around arbitration
The
rulings?
answer is yes.
Yes. Well, this is a perverse result of mandatory arbitration, where you're shoehorning statutory claims that ought to be in court into arbitration, and arbitrators are supposed to apply the law. But we all know that they don't necessarily follow the law, and to the extent that they don't, it's non-reviewable. Arbitrator decisions are not appealable. They can be reviewed if there's fraud, corruption, duress, or other narrow circumstances. And there's this piece of the law that's not even in the statute, where the courts have developed a manifest disregard of the law standard for review, where under certain circumstances, if the arbitrators are aware of the law, and they deliberately ignore the law in their decision, that can be reversed. So there will probably be more of those kind of cases as more and more cases get pushed into arbitration.
It will be an increasingly difficult but important decision concerning whether you want to commit your employment-related disputes exclusively to arbitration, as from time to time there'll be well-publicized runaway panels, limited use of the rules of evidence, no regard for precedent, and exceedingly limited appeal rights. You win, you may lose, but it may very well be that we're facing this difficult point of decision. Do we want to put all of our hopes in the fact that arbitration may be more efficient, maybe more manageable, expose us to less media attention, but you'll run the risk of a very bad result and no realistic way of turning it around? I want to take issue with just one thing my good friend Wayne said. I don't hope by any means you pursue this to your death, Wayne, but the Supreme Court decision in Concepcion dealt with the very same issue of whether an individual consumer of telephone service would have motivation depleted to pursue a real grievance if they couldn't be part of a class because a lawyer wouldn't take the case for only a few dollars because some consumer was irate about a phone bill. That's the same issue with wage and hour. The Supreme Court answered that argument. It's not a contract of adhesion simply because it's more difficult to get economically motivated and motivate an attorney to pursue a claim for only the individual grievant, not part of a class. Most companies these days cannot afford the risk of loss of a class action. Most companies these days want no part of the seemingly endless struggle of defending a class action. As a consequence, they're driven by settlement, not disposition on the merits, and that's the sin that's trying to be addressed by forcing individuals to say, if you've got a claim, you have the right to prosecute it, but you don't have the unalienable right to bring others along with you.
In my one word in defense of the AT&T case, it was an unusual arbitration agreement in which the arbitration agreement was written to make it viable to arbitrate on an individual basis. So that's something employers might want to think about if they're going to bar class actions, to create minimum damages and attorney's fees provisions that make it viable. I feel the cane now coming to pull me off the stage, so I want to thank you all very much.
Are we lucky? And we have to thank Jerry Capelli and the whole panel and Cindy. Thank you. Thank you all for coming, and don't forget to hand in your white forms and your blue forms as you're leaving. And thank you again to this panel and Cindy and Jerry. Thank you, thank you, thank you.